Good afternoon, everyone. Today is March 13th, but more importantly, it's Friday. So we are going to have two bill hearings today, followed by a vote session. We're going to start with Delegate McComas, House Bill 1586.
Madam Chair, can I bring up my panel?
Yes, please.
Thank you.
And whenever you're ready, you may begin. Are you Ms. Whittingham? Whittington, I'm sorry.
Yes,
Okay,
Madam Chair.
Great, thank you. Delegate, whenever you're ready.
One second. Do you want the lady, Judge, the wife of the person that killed Judge Wilkinson first?
No.
No, okay, all right. Madam Chair, this is Darlene McLaughlin, and this is,
Krista Whittington.
right. Okay, all right.
And the only thing is, we need you just to move your microphone over,
Sorry.
Delegate.
Yeah.
Thank you so much.
This is HB 1586. I'm the sponsor, Delegate McComas, Protective Orders, Coercive Control. The Duluth Domestic Violence Power and Control Wheel in 1984 is a great tool to help victims of abuse to understand the power and control dynamic. Although the perimeter of the wheel represents those forms of abuse, physical and sexual, which seem to be most often in the public eye, the inner workings of the wheel outside the many forms that abuse can take. For those suffering from coercive control, control is at the core of the abuse cycle. The strategies and methods abusers implement are among the spokes of the wheel that represent the victimization of those who have lost their ability to live without fear of reprisal, domination, intimidation, isolation, and economic and emotional abuse. The earliest version of this bill was heard in 2023, lacked a definition that resounded with the Judiciary Committee. In 2024, HB 1290 included the definition for coercive control as recorded in Maryland Rule 9-205, December 2022. And that definition was a pattern of emotional or psychological manipulation, maltreatment, threats of force, or intimidation used to compel an individual to act or refrain from acting against the individual's will. Despite the legal definition as set forth in the rules and included in HB 1290, there were those who opined that the definition remained too vague. With that in mind, HB 1586 has expanded the definition to provide the court with examples as set forth in the California Protective Order Statute within their Family Code article. As of 2024, 9 states have codified coercive control in their family, criminal, and or protective order statutes. Although the already defined is its Family Court Order Act, New York is currently considering coercive control in its statute for an order of protection. It's time to recognize coercive control as that which robs the victim of their power to make decisions about something as simple as what to wear, how to talk, and what time to go to and from daily activities. Life for the coercively controlled abuse victim gradually becomes so confining and manipulated that the abuser has all the power over them. The victim has no personal freedom whatsoever. The home, in fact, becomes a form of confinement and isolation from others, a prison for the victim at the hands of the manipulator. Victims of coercive control often have no physical signs of abuse. They frequently do not have bruises, cuts, broken bones, or other outward signs. They are told when and how and why to do something. Sometimes their food is withheld because they did not comply with the controlling edict. Their activities on the phone or computer are thoroughly scrutinized and sometimes cut off completely. Email, text, social media are forbidden as it represents an avenue of communication with the outside world the abuser cannot fully control. Your Honor, or Madam Chair, can I finish? It's not too much longer. Okay, they simply have no autonomy. Imagine living that way day to day. Someone tells you how, when, where, or even if you can go. If you fail to follow the edicts, there are severe consequences suffered by the victim, their pets, their children, or their loved ones. According to the National Domestic Violence Hotline, it takes a victim 7 attempts to fully leave an abusive relationship. These statistics often raise the question as to why it is so hard to leave. Domestic violence was once thought to be an anger management issue. It is now currently recognized that at the core, the abusers have a sense of entitlement and a belief that they should be in control. HB 1586 recognizes the domination and control of a victim through coercive behavior that strips the abused of their ability and freedom to make self-effectuating decisions. HB 1586 recognizes coercion as abuse and gives the victim an outlet from the controlling behaviors that rob them of their own self-will and provides them with a path to escape their abuser. Please consider giving a favorable report for HB 1586. Thank you, Madam Chair.
Thank you.
Madam
Ms.
Chair.
McCall?
Thank you, Madam Chair, and fellow committee members. My name is Darlene McLaughlin. You may know me as Delegate McCombs's legislative staff. I am a grandmother of 29, a survivor of 25 years of coercive control, 6 children, of which 2 suffered severely from his coercion as well. They escaped. The effects are still far-reaching. Delayed getting their degrees. I got my degree at 54, earned all 3 in 5.5 years to prove to him that I wasn't the person and that he was teaching my children that I was no good, that I was a piece of, and I didn't have any self-worth. There was times where I was given veiled threats, such as we had a farm. You know, if you fall into the hog pen, they will only find your teeth. This was a very real threat to me, very, very real. If you leave me, I will take your children from you and lie about your character. My children define who I am. My grandchildren are the legacy that I've left, 29. They don't know what I went through. There was one child, my oldest, that saw it day to day. She was a victim as well. She survived. There was eventually an event where I was actually pushed down steps backwards, dislocated both of my thumbs, had bruises all over me at the appropriate times. And it wasn't until then that I could prove that I was being forced to do things I did not want to do. And because I did not want to do something that day, he pushed me, and I was on the top of the stairwell. It could have been much worse. I could have broke my neck. My thumbs took the worst of it. My kids saw it happen. They were petrified of it. My sons would whisper, "Mom, I don't want any trouble." And they wouldn't go with me when it was time for them to stay or see me. They were his minions. The older boys would throw things on the floor, push the food on the floor, and tell the judge that I wasn't feeding them. They would open doors. He taught them to open the sliding door in the back of my home so it would be cold in my house, and tell the judge that I wasn't keeping the house warm. This is all a form of coercion control, and the tools that they use. He threatened my pets. He killed one of my pets. The 25 years have passed, but it's still as real as it just happened. And unless you're a victim, unless you're a survivor, and Judge Wilkinson paid the highest price of realizing what coercive control was, unless you're a survivor or currently in the situation, you have no idea how very serious and dangerous these people can be. They're narcissistic, they're sociopaths, some of them are psychopaths, and they have no boundaries. If there was amendments proposed, if you don't like the way it's defined, please offer them, because we really need to protect victims that have no voice, that are locked in a room or told they can't drive. My marriage was during the time when you didn't have cell phones, you didn't have the internet, and there was codes put on my phone, my house phone, so I couldn't even call out. I had to get a court order to allow me to use the phone to call the pediatrician, my doctor, and my attorney, and that was it. Oh, and 911. So there was, his control was all far-reaching because the property was all in his name. I had no control over the phone line. I had no control to be able to stay or go. He controlled all of the monies. He controlled whether I had access to phone numbers. I had to hide them in the linings of my shoe underneath the tennis shoe's inner sole, so I could remember phone numbers when I got out somewhere. I could call someone. So you, unless you're a victim, unless you're a survivor, you have no idea what these people go through. And this made me stronger. This got me through law school. This got me here with Delegate McComas. And you all have victims. You either know about them, you're ignoring the situation because it's not your business, or you've seen the ultimate effects of it. So consider HB 1586 either in its form or in an amendment form, and please offer the amendments. Thank you, Madam Chair.
Good afternoon, Chair Bartlett, Vice Chair Davis, and all members of the House Judiciary Committee. I thank you for your time regarding House Bill 1586 today. I come to you today to let you know that a few years ago, I called the police as my abuser was at home throwing my belongings out of my car all over my yard. He stole my car from my driveway in front of the police and my 2 children. This was the only mode of transportation to work and school that I had. It left the children and I stranded for a week. At that time, my abuser had not lived in my home for over 2 years because of 2 prior protective orders which had expired on that date. Yet he refused to release control over me in many ways. The car was still in his name. He stole my car because there was a financial check that he wanted from me. When he wasn't getting his way, he stole my car. As the police stood there with me that afternoon, they said there was nothing that they could do because he wasn't under an active protective order, and that I probably couldn't get one because he hadn't assaulted me. No one should have to live like this. Experts say physical violence is just one of the ways that dominance is maintained in domestic violence cases. While coercive control is a known risk factor for abuse and can escalate to assault or even murder. My abuser then assaulted me a few weeks later, trying to steal my car a second time. This time, he was under an active protective order and he was arrested. The courts then extended my protective order for 2 more years. His aggressive, intimidating behavior was a pattern. This wasn't normal marital issues. I'm here today to use my voice on behalf of coercive control victims here in Maryland. As you will see in your testimony folder, there is a letter from the lawyer who represented Pedro Aragote's wife. This guy was a monster, and his wife saw patterns. Unfortunately, she had to live isolated like so many of us do. She was controlled day in and day out, and in just a few moments, you will hear from her. When the divorce hearing was final, Pedro Aragote shot Judge Wilkinson in Washington County point blank in his driveway as his last act of control. Those who have submitted unfavorable testimony today actually isolate victims like myself and Pedro Aragote's wife further from safety. The Maryland courts have been in conversation with us and have stated that they are happy to accept amendments to this legislation to allow coercive control as grounds for a protective order, and I urge your favorable report, please.
Thank you very much. Members, do we have any questions? Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill, and to both of the witnesses. I really appreciate you being here. I know, Ms. Whittington, you were kind of cut off there at the end, and I know we discussed a little bit of the testimony from Ms. Ms. Johnson, Esquire. Was there anything that you didn't have an opportunity to speak that you wanted to kind of let the committee know today?
Well, coincidentally, Ms. Johnson actually is in court today defending a coercive control and domestic violence case, so she was unable to be here. Victims of coercive control deserve access to meaningful legal protection from violence. She works closely with many domestic violence cases out in Washington County, and again, urges your favorable report.
Members, are there any other questions?
Do we have?
Okay, seeing none, I'm going to move on to our virtual panel favorable. Ms. Eugenia Malpica and Christine Cochiola. I'm sorry, Christine is not there? Okay, so we will go with Ms. Malpica, please.
Yes. Hi. My name is Eugenia Malpica. I'm here today in support of House Bill 1586. I'm a survivor of coercive control. I am able to speak today because my children and I are finally safe. For years, coercive control shaped nearly every aspect of our lives. Financial decisions were controlled in ways that made independence extremely difficult. Access to transportation was absolutely restricted, limiting my ability to move freely and make decisions for myself and for my children. There were also repeated threats that if I attempted to leave, my children could be taken away from me. Those kind of threats created an environment of fear, pressure, that can make it incredibly difficult for someone to safely change their situation. Coercive control does not begin with physical violence. It begins with patterns of intimidation, manipulation, isolation that slowly remove a person's autonomy and sense of safety. In my case, those patterns escalated in ways that ultimately led to the tragedy that took the life of Judge Andrew Wilkinson while he was doing his duty to protect families through the legal system. Sorry. That loss was devastating, not only for his family, the community, and everyone who believes in justice. It is also a reminder that warning signs of coercive control often appear long before situations escalate to such tragic outcomes. This bill recognizes the abuse is often a pattern of behaviors designed to control or intimidate another person over time. By allowing courts to consider coercive and controlling behaviors when evaluating protective orders, this legislation gives the legal system an earlier opportunity to intervene before situations escalate further. Recognizing coercive control in law could help protect families earlier and potentially prevent tragedies in the future. For these reasons, I respectfully urge the committee to support House Bill 1586. Thank you for your time and consideration.
Thank you, Ms. Malpica. I appreciate you sharing your testimony today with us. Members, do we have any questions? Delegate Valentine, thank you.
Thank you, Madam Chair. Not for the virtual witness. Can I have a question for the panel?
And in fact, I need to go back to the panel because I have a question too, so I'm glad you violated the rule.
Forgiven.
Thank you. And Ms. Whittington touched on it briefly, but this question's to the delegate. She mentioned about the judiciary. I know they came in unfavorable on this, but I know that they are willing to at least entertain some amendments. Is that something that you're currently in the process of working with or looking forward to working with to maybe?
Looking forward sooner rather than later. But I think the problem is I know it's difficult, but you know it when you see it. It's like pornography. You know coercion when you see it, honestly.
Yes.
And I think there's got to be a way we can do this. I know they use coercion within the rules that if they feel there's a coercive relationship between the domestic folks when they go in for mediation, they do not let them mediate with one another. They don't do it because they're concerned about coercion. And that's a situation where it's, they say, well, they can't negotiate any type of, custody visitation or anything. So this is a lot more serious situation, and certainly what happened to the person that killed Judge Wilkinson, I mean, he was a tyrant. And, you can still see the kind of the scars from his ex-wife. She's still hurting. I
do.
So I think we have to recognize that. And in fact, I was going through a lot of information, and basically it used to be, well, you had to have bruises or marks and everything. But I was speaking to a lady who she's involved in litigation, divorce.
Understood.
But I spoke with her for over an hour yesterday, and it was so depressing. The only thing I could say is God help you, because it's horrible, because she was a great wife. And I can't say any more really because I don't want to identify her, but the point is the kids are suffering from all this too, and it has a ripple effect. It has a waterfall effect that it affects everybody, And without getting into any particulars, it's just very sad as to somebody that's very intelligent. The one that's doing the coercive control is very intelligent, but he's made her life miserable. And I offline, but not publicly, will I discuss the thing, but it's serious and it can affect people's health. Your mental and your physical and your emotional.
Thank you.
Thank you, Madam Chair.
So, but I am willing to work with anybody that, and certainly there's some bright folks here on this committee. We don't, and I think that the domestic violence folks are, they always look at the negative of something instead of the positive because they're so fearful that it'll get used against their victims. And I'm not convinced that's the fact. And you could also use, and it's possible, you could have folks that could maybe interview the parties before they go to court and just kind of get a feel for the, separately. But I've actually seen coercive control even across the street from my neighbor. The daughter was never allowed to go see her family after she got married to the guy. Well, something magically happened and they're all together now, but she didn't go to her sister's wedding. She didn't go to her sister when her sister had a baby. She didn't see her parents for several years. And, it met that profile. So it happens.
There's one more witness on the virtual.
Oh, and we also have one more witness on the virtual.
Yes. So I had just one quick question. Delegate Valentine, did you finish your question? Okay. And members, do we have any other questions? So I just have one question, and that is with respect to having this in the protective order section. And I know you've brought this bill many times. Has there ever been any movement outside of the protective order section of the law? Because the premise behind a protective order is that a person is in immediate fear of danger of their life. And whereas with coercive control, it is not immediate. So my question is, has there ever been a move to get it out of protective order and in somewhere else, just historically? And Delegate McComas, I know you don't like microphones, but I need you to move that microphone over. There
Sorry. Nothing that I'm aware of that has done it through the protective order system, but what I'm saying is maybe what they need to do is have folks talk, kind of have a questionnaire or something, because like when you go into a doctor, they say, well, do you have guns, or you have suicidal thoughts? Do you suffer from depression? Something like that would be structured toward analyzing whether there's coercive control. And then if there is, maybe you don't want to go for the immediate order, but you might want to get people in counseling. But the problem is let's say somebody is found guilty of domestic violence. They send them to anger management, and it seems that the whole paradigm is shifting toward power and control, which is the center of that wheel. And I don't know if everybody was distributed a copy of the wheel, because we can't use big banners or big posters, but that's very helpful, because if you look at the new information online, it talks about its power and control as opposed to, anger management. And so that needs to be the paradigm shift. And it's more, the power and control is much more insidious than actually, getting kicked in the shin or in the face. Actually, it's more painful because it really takes away a person's individuality, their ability to be resilient. I know that my aide, Darlin, would never have gone to college or law school if she'd still be with her ex. She'd probably be in the pigsty with just her teeth. So that's kind of, so this can be very, very dangerous. And so we need to appreciate the seriousness of it, with also trying to deal with the fear that the domestic violence community has, that it's going to be used against the women. I don't think, if you had a sort of like some type of filtering, that people that are social workers or people, the LCSWs or whatever, that are sort of trained in gearing with domestic violence. The other thing I would say is that there's also the issue of ACEs. They talk about ACEs, adverse childhood experience, but this is sort of adult ACEs. So, and I think we need to be aware of that, because people can develop anxiety, depression, become suicidal, become inability to do things. So it's a public health issue.
I understand. Yes.
I could address it a little bit based on my legal training, but the coercive control was put into the rules to be utilized in criminal matters, and it's considered, when a judge does his due diligence, it's considered in his work in a family law realm. And that's what Judge Wilkinson did. He used that definition and applied it during that trial. The key is that to get the relief that a victim is seeking, you would seek it through the protective order, because it's often, if you wait too long, like if, for example, if I had done something that raised desire, whatever it was, for example, letting my daughter go to a church group meeting, and then he forced her to work every night after that. She never had a night off. We had an Exxon station. She pumped gas 365 days a year until I got out of there. The idea is that if you need immediate relief, you're not going to get it in the family law. And if you wait and go through the family law courts, if anybody's gone through a divorce, it can take months. 18 months is not uncommon. And then in that 18 months, you're getting targeted and possibly a victim of more serious, or even your children or your pets, or in my case, it was my favorite car. He destroyed it. So I didn't care about that as much as the kids. I just wanted my kids safe. I wanted them to go to college. I wanted them to have a life of their own. I wanted them to make decisions on their own, not based on what dad said about me or them, or that they were just like me, no good and never going to make anything of themselves. That a child should never hear from their parent. So to get that relief, we put it into the protective order so that we can get something significant. Take the abuser, take the coercive, the narcissist, the control freak, whatever you want to call him, he or she, it could be a woman, I don't want to be sexist, take them away from the situation, give them, the victims, an isolation from that, some insulation from that, so they can seek a divorce, so they can get a divorce, so they can make a decision. And often when the control is in the financial realm, that you're choked off because you can't get a lawyer. Luckily, I had a father with money.
Right.
So it's in the statute, but it's not in the protective order.
I see. Ms. Whittington.
Madam Chair, if I could just have a few more moments of your time. I didn't put this in my testimony, and this is very personal, so I wasn't going to share it, but I just feel led to share this. My first protective order that I obtained on my abuser was because he assaulted me and raped me in the middle of the night. From that moment forward, carrying on, I had a lot of physical health and a lot of damages that were internal. Some serious health issues that actually ended up destroying my teeth. So a year and a half ago, I lost all of my teeth because of the stomach ulcers and because of all of the damage and all of the medicines that I was on. Again, that's very personal, but when you say you can't see the bruises, just know that the smile you see today is from domestic violence. So again, I didn't put that in my testimony, and it's very hard for me to even speak about, but coercive control is hidden, and most of us that go through coercive control are hiding a lot. And we just need relief, and when we ask for it, we don't want to have to prove it.
Right. Understand.
And we can't wait.
I understand. Okay, Delegate Simpson.
Can I add something to that? If I'm allowed?
Oh, Ms. Malpica, can you turn her up just a little bit? Sure. Did you want to add something, please?
Yes, I just wanted to say that in my case, very specific, and I know this is something that can happen to anybody else. if I would have been able to get a protection order, he would have been taking away his gun from him. And Judge Wilkinson might have been safe from Pedro, just from getting the protection order that I didn't get.
I understand. Thank you. Thank you. Delegate Simpson.
As a survivor, I do understand. I do understand how brutal and painful coercive control can be. I hope we can also agree that we're not going to make comparisons of different folks' experiences. You know, there are people who have lost their lives and all sorts of other things. So being kicked in the shins is still very painful, or hit in the face. We don't have to, if we're in a body that we can agree that all of these things are awful and that we need to come up with solutions. So my question is what have you done, how have you worked with the domestic violence and other, the groups, and the judiciary to get this to be a bill that will work?
I did have a conversation with, I think Lori Ruth, okay. And of course, they've written all kinds of, negative information. The problem is that they're more concerned about their clients than the problem, okay? And so it's the what if. Well, I basically, it's the committee's bill at this point, and I'm not the greatest wordsmith in the world, but I think we've got to do something that infuses that, because 9 other states have it, and it just seems to me that there's a mechanism, even if it's a screening process, that because what she went through is horrific, okay? Both these ladies and the woman I spoke with. And I mean, the kids are not being well cared for in the situation that I spoke about, that I spoke with this person for an hour last night. And I was speechless. I have no remedy for it.
Well,
I would like to work with folks, and I would like to work with you since you're on our committee. Certainly, Darlin's an attorney with our other panelists. I mean, the problem is that I understand the need for protection of the victims, and we don't want people to get, we don't want it used by the abuser. But on the other hand, I think these situations need protection, because we have one judge that got it.
I mean, there are suggestions that are in here from these groups. So I would say that the same things that many of us on this committee and throughout this body have done, which is sit down with the advocates. And so that, I mean, as someone who is a survivor, I don't have all the answers about what's going to work in the courts. I know when it hasn't worked. And that's why I meet with, whether it's the attorneys, whether it is the Maryland Judiciary, I'm asking for those meetings, particularly during the interim, so that I can come up with a bill that's going to work and at least start to make things different. Yes, our system is broken. That is definitely for sure. But sit down with them. I mean, there are things in here they actually suggest.
Well, but they haven't presented any language that they wanted. They just make kind of vague reference. I'll be glad to bother them, to work on them. But they don't. But if you read their whole testimony, there's a lot of fear in there.
When a victim is able to get out of a terrible situation, you've not bothered a single person. So if we can improve the legislation so that it can make a difference, it's no bother.
Well, I'll be glad to work with you. I'll be glad to work with anybody. The problem is that this just got out of rules, and literally.
Okay. Can we agree not to compare the different types of abuses and make one worse or better than another, or say that a victim can't understand, this, if they've just gone through that. Can we agree to that? Can we agree?
Oh, well, I think the fact we're here about coercive control says it should say that we agree.
Thank you.
Go ahead, darling.
One of the things I did before, I drafted the new language in here. I took it from the California statute. Delegate relies on me because of my legal training and because she's very busy. I did reach out to House of Ruth, Laura Ruth. I asked them, please look at this. They got the bill right as soon as I got it from drafting. Please tell me, what is your perception? What changes do you, think should be done? I'm open to suggestion, but their most frequent response was, I have to talk to all of their other, people that work within their domestic violence realm and make sure that they're all, cohesive and
that's because of
one
unintended
united
consequences. As a person that is on the Family Violence Council and someone who's been doing this work since, well, I guess because of being a child in an abusive home, someone who's been doing this since the day I was born or probably even before, we don't want unintended consequences.
Right.
So it's okay if a bill takes a little while because we want to make sure that it doesn't hurt. We just want to help. And we already know, many of us on this body have been through these things. And we have wrestled with the courts. And we want the courts to work better. And we want to make sure we avoid any type of unintended consequences. And that's why I sit down with the advocates.
Well, perhaps Delegate McComas has hit the nail on the head in saying that a judge should appoint someone to evaluate, to be neutral, listen, hear, and then report to the judge their perception with experience like yours, where you can see that it's someone who's got what I call the sheep in wolf's the wolf in sheep's clothing, that acts like he's little Bo Peep, but he's really, Snidely Whiplash. So the idea is that there has to be some way the judge can hear what he can't see, some way he can evaluate what he doesn't get the benefit of a neutral evaluator. So in a sense where there's a protective order requested under coercive control, it may have to take a little longer. There may have to be a time, like in Baltimore County, they have a custody evaluation offered to custody battles. So perhaps there has to be.
These are all great ideas. They sound like a great beginning of a work group.
Okay.
So that's what, I think delegates on the right track.
Okay, so here we go. I think that part of a bill hearing is discussing ideas, asking questions, and getting feedback. And so that's what I'm hearing here, and I think that's good. And we can never underestimate the value of a work group because then it becomes a singular focused, and you're not prohibited by time and things of that sort. So that is something to think about. I think this is an innovative idea, but it addresses a very, very serious problem. So I thank you, all of you all, for coming in and testifying. And Ms. Mapika,
I think there's one more lady to
testimony.
testify on the virtual.
Yep. And so, Ms. Mapika, I appreciate you being here. Is Christine Cochiola available online? No, ma'am. We don't have her online. It can.
She might have had.
Do we know where she is?
She was traveling, Your Honor, and she told me she had a limited window, so she said, Madam Chair, I'm in the courtroom. She told me that if she's not there, it's because she no longer had access to the internet.
Yeah, and that's probably what happened.
And I apologize, but she did provide her written testimony.
That's good enough. Okay. Well, thank you very much. And that excuses this panel. We don't have any further questions. Okay.
Thank you.
Thank you, Madam
Thank
Chair.
you.
And thank you,
Thank
panel.
you.
Or thank you, Committee Chairman.
Okay, we're going to call up Lori Ruth, if she's here. She's in Zoom. Okay, perfect. Okay, Ms. Ruth, whenever you're ready.
Madam Chair, I'm sorry to have to ask you this. I've been trying to get on the other screen to watch. So am I just doing opposition to 1586 right now?
That's absolutely correct. Opposition to 1586.
Okay. Well,
Thank
I
you.
apologize because I didn't hear the proponents. So I will just go on the record to say my name is Laurie Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence, and we oppose HB 1586. It's a little bit of a bill, a little bit like yesterday's DV registry bill. I fully realize that it is well-intentioned. And in fact, since this has first been brought by Delegate McComas, the world in America and the other states has changed a bit. So at the time that it was first brought, there were no other states that had it in their protective order bill. Now there are 12 states, and I just want to be an honest broker here and set the landscape because it has progressed. Nonetheless, we stand in opposition because I think what we hear most from programs and our members and constituency is a genuine grave fear that it's going to be used against our clients, the true victims. And the example that I've heard most often is that victims and survivors living in domestic violence often go through the phone of their abuser because they're trying to get some control and understand what's going on. And, they're very afraid that that's going to get turned around to have a protective order brought out on them for some sort of coercive control because they're, going into the person's phone and whatnot. And I think that that's even more likely to be used. They're going to try and characterize protective behavior by victims and survivors, especially when children are involved, as coercive control and use it against our constituency. So I put in my written testimony that I thought that we should do a big review of protective order law, and that's what Washington State did. So they had a 320-page document, and then the next year they added coercive control to their statute. And you can see my written testimony for anything else, but essentially we oppose this bill. Thank you very much.
Thank you, Ms. Ruth. Members, do we have any questions? Yes. Delegate Erica.
Thank you, Madam Chair. Thank you for being here and sharing your thoughts. So for the 12 states, could you just tell me which states those are if you have the list handy?
Oh,
and then
gosh.
No pressure. We can talk offline as well. I was
Yeah,
just very curious.
I can get it to you. I don't think I wrote them down here. I'm sorry. I'm sort of half on vacation. I don't have everything in front of me.
That's okay. I know we said California for sure has it because that's so
I can get you the list very easily. I just don't have it right in front of me.
okay. And then for the states, have you heard any really negative stories coming out of these 12 states yet, or is it just too new for us to know?
I think it's too new. I did look around earlier in the session when Delegate McComas told me she was going to bring this bill back, and I don't think I got far enough, quite honestly, just got taken up by other things. Because like I said, it's a hard thing. We all recognize that coercive control is all over these cases. It's a very big part of these cases, but I know working with the National Coalition, there is always concern about it being misused.
Yeah. Some of these abusers are very high IQ, as it turns out.
Oh, right.
They're very smart
Pretty
about their
savvy.
abuse. Yeah, very savvy abusers, unfortunately. We all like a nice dumb abuser. So, but anyways, here we are. Thank you very much.
Thank you.
Thank you. Members, do we have any other questions? And seeing none, and we don't have Ms. Cochiola, right? Okay. Seeing no further questions, that concludes this panel and our bill hearing for House Bill 1586. I think I see Pages. I thought I saw Pages. And I see one Page who's here, and she's trying to hide behind a piece of paper. I'm not. Oh, okay. Oh, okay.
Very sorry. I didn't hear a great jacket. I'll pretend to be one. No. I was witness.
Oh, Okay. So I don't know if we have, I don't think we have the pages anymore, but we did appreciate having them here. And we're going to move on now to House Bill 1608, which is my bill, and I'm going to turn it over to the Vice Chair, and I'll get over there. All right, while the chair is heading to the seat, I am going to call HB 1608, and we have Daniel Segara, Karen Herron, we have Aaron Earp virtually, Robin Elliott, Mary Berger, and Catherine Ling, and Layla Gretton. Can we all get there? Did I call too many? I think we have, do we have everyone? Yep, have a seat, wherever you like. Okay, all right. Thank you. We'll get you next, okay? We'll get you next, thank you. All right. Madam Chair, you may proceed. Thank you. Good afternoon, everyone. My distinguished fellow members of the House Judiciary Committee. Today, I am here to introduce House Bill 1608, Public Safety Firearm Storage Requirements. This bill is a careful revision to Maryland's firearm storage laws designed to address a tragic and preventable problem: children gaining access to unsecured firearms. First, just let you know, under current law, a person is already prohibited from storing or leaving a loaded firearm where a minor could gain access to it. House Bill 1608 expands this prohibition to both loaded and unloaded firearms, and I'll explain why, as both pose dangers to minors. Second, House Bill 1608 refines the statutory language describing the prohibited conduct. Current law refers to situations where an unsupervised minor has access to firearm. House Bill 1608 focuses on circumstances where a minor is likely to gain unsupervised access to a firearm. Stick with me, and I'll keep explaining. I'm just gonna layer it on, and then I'll keep explaining it. House Bill 1608 centers on whether the firearm is stored in a way that makes unsupervised access likely, encouraging reasonable storage practices and emphasizing the duty of firearm owners to anticipate foreseeable risk. Third, House Bill 1608 creates two new exceptions to the statute. This prohibition doesn't apply if a minor obtains the firearm in an act of self-defense or defense of another. It also doesn't apply if the firearm was stored in accordance with secure storage requirements outlined by the bill. These provisions protect responsible firearm owners and ensure that individuals acting in legitimate self-defense are not penalized. Fourth, House Bill 1608 addresses accountability when negligent storage contributes to harm. Under current law, a violation of the child access statute cannot be considered evidence of negligence or contributory negligence in civil cases involving property damage, personal injury, or wrongful death. House Bill 1608 repeals that restriction, ensuring that courts and juries may consider all relevant evidence when determining responsibility for injuries caused by improperly stored firearms. And last, House Bill 1608 establishes a graduated penalty structured to address repeated violations. First-time violations punishable by a misdemeanor, fine $500. Second-time violation, carry a maximum fine of $1,000. Third offenders are assessed a maximum fine of $1,000 and prohibited from possession of a regulated firearm, handgun qualification license, and permit to wear, carry, or transport handguns. The need for this legislation is not theoretical. In February of this year, a 6-year-old child in Montgomery County gained access to a firearm and died from a self-inflicted wound. A second grader gained access to a firearm and brought it to school. No one died, thankfully. Horrifying or horrific incidents like these devastate families and communities. When firearms are not stored securely, children can and do find them. House Bill 1608 seeks to prevent tragedies like these by ensuring that firearms are stored responsibly when they are not under the direct control of their lawful owners. For these reasons, I urge a favorable report on House Bill 1608, and thank you for your time and consideration.
Good afternoon. I'm Karen Herron, Executive Director of Marylanders to Prevent Gun Violence. Thank you for the opportunity to testify in support of HB 1608, establishing minimum safe firearm storage standards. Over the past year, we have seen a series of tragic and almost tragic incidents involving children accessing unsecured firearms. These are the stories that make the news. A child finding a gun in a bedroom drawer, in a backpack, or in a vehicle, and someone ends up injured or killed. Each time, communities are left asking the same question: how did a child get access to a gun in the first place? 3 years ago, this body passed Jalen's Law, an important step forward in addressing these risks. But what we are seeing today tells us that it is not enough. Limiting storage requirements only to situations where children are known to be present simply does not reflect how our lives actually work. Children move through our homes and our communities, visiting friends, relatives, neighbors. Family structures change, relationships change, and firearms that are left unsecured creates risks for anyone who may encounter them. This legislation moves us toward a culture where safe storage is the norm for responsible gun ownership. The research is clear. Millions of children in the United States live in homes with loaded, unlocked firearms. But this issue is not just about children. Unsecured firearms are also a major driver of gun theft. Each year, tens of thousands of guns are stolen from homes and vehicles and diverted into illegal markets, where many are later recovered in connection with violent crimes. This is about establishing reasonable minimum safety standards, the same way we have done with seat belts, swimming pool fencing, and other public safety measures that save lives. Responsible gun owners already store their firearms safely. This bill helps ensure that safe storage becomes the expectation for everyone. We urge a favorable report. Thank you.
Good afternoon. My name is Daniel Segura, State Policy Manager with Brady Campaign to Prevent Gun Violence. The bill before you today, HB 1608, will encourage responsible and safe firearm storage practices and save lives across the state of Maryland. This bill would bring Maryland's secure gun storage law up to the gold standard by requiring all gun owners to securely store their guns when not being used or carried. It would raise the storage standard of Maryland's existing child access prevention law to require storage in a secure storage depository at all times that the firearm is not under the person's direct control. As noted, just last month, tragically, a 6-year-old boy died after gaining access to an unsecured firearm in his Montgomery County home. Nationwide, more than 4.6 million minors live in homes with unsecured firearms. 92% of those firearms used in accidental shooting deaths among children were left locked and unlocked and unloaded. And 70 to 90% of firearms used in unintentional shootings, school shootings, and suicides by minors are acquired from the home or from homes of friends or relatives. The data is clear. States with secure storage laws see a 59% decrease in unintentional firearm deaths, a 78% drop in unintentional shootings committed by children, and a 26% annual reduction in self-inflicted firearm injuries among youth. As well, firearm suicides among minors have doubled over the past decade. Meanwhile, studies show that child access prevention law enactment is associated with a 26% annual reduction in self-inflicted firearm injuries among youth and an 8% decrease in overall suicide rates among 14 to 17-year-olds, strongly suggesting that when firearms are inaccessible as a result of these laws, minors are not substituting firearms with other methods. Secure storage creates a barrier that saves lives. And as I've explained fully in my written testimony, this does not infringe on Second Amendment rights. Brady strongly encourages a favorable report on HB 1608. Thank you.
Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Molly Berger. I'm a Maryland resident and a member of the Law and Policy team at the Johns Hopkins Center for Gun Violence Solutions. Safe storage laws are among the most well-studied and evaluated state gun laws. Numerous studies show that these laws are associated with reductions in all forms of gun violence, including firearm homicide, suicide, and unintentional shootings. This testimony represents our strong support of HB 1608. Far too often, someone in crisis gains access to a firearm of a family member or friend that is left unlocked. An estimated 82% of adolescent firearm suicides involve a gun belonging to a family member, and approximately 74% of school shooters access a firearm from either their own home or the home of a friend or relative. Firearm safe storage laws are based on a core tenet of injury prevention. Separating at-risk individuals from potential sources of injury can save lives. Research suggests that adopting safe storage laws could specifically result in meaningful reductions in firearm suicide and unintentional firearm fatalities among youth and veterans. Though gun violence is often concentrated in urban areas, rural areas experience higher rates of firearm ownership, suicide by firearm, unintentional shootings, and unsecured firearms in homes with children. As a result, rural areas stand to benefit from the adoption of safe storage laws. In addition to being one of the most effective gun violence prevention tools, safe storage policies are overwhelmingly supported by gun owners and non-gun owners alike. 74% of Americans, including 62% of gun owners, support laws requiring someone to lock up their guns when not in use. Maryland has made significant strides in addressing gun violence, but too many families continue to lose loved ones. Safe storage laws are an effective, evidence-informed method to save lives. The Johns Hopkins Center for Gun Violence Solutions urges a favorable report. Thank you.
Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and esteemed members of the House Judiciary Committee. My name is Layla Greeton. I'm a high school senior at Archbishop Spalding High School and the founder of Team Enough Baltimore, a youth-led initiative under the Brady campaign, and I'm here today to voice my support for House Bill 1608. This bill will allow Maryland to follow in the footsteps of Rhode Island, Massachusetts, Oregon, and other states by mandating gun owners to practice safe storage. Safe storage is one of the most effective ways of reducing gun violence, especially for my generation. Children have a 78% lower risk of self-inflicted injury and 85% lower risk of unintentional injury when safe storage is practiced. And one study estimated that if even half of households with unlocked guns switched to locking them, 1/3 of youth gun suicides and unintentional deaths could be prevented. That's 251 lives. More than 4 million children live in homes with access to unlocked and loaded firearms nationwide, and more than 70% of those kids know where a gun is located. Just last month, a 7-year-old brought his mother's boyfriend's gun to school and discharged it in the classroom, resulting in an injury to his hand right here in Anne Arundel County. 1 year ago in Baltimore County, a 9-year-old girl fatally shot herself in the head with her grandmother's gun kept unsecured. 75% of school shootings are facilitated by kids having access to unsecured guns in the home, and over 1/3 of adolescents in a firearm-owning household report being able to access a loaded firearm within 5 minutes. Children in the state live with the fear of someone bringing a firearm to school daily. We are expected to memorize different emergency plans based off what location we are in proximity to a shooter. The only thing students in Maryland should need to memorize while in school is their math formulas, history dates, and when their next essay is due. Furthermore, youth suicide is a growing epidemic in our state and our country, and that is only facilitated by the access to firearms. 75% of youth suicides by a gun were with an unlocked and loaded weapon. The data has shown putting a preventative barrier in place by safely storing a firearm can greatly decrease the risk of suicide in teens. We need to protect children from unintentional harm or injury. Maryland secure storage guidelines must be updated to ensure safety for young people across the state, and I strongly urge a favorable report on House Bill 1608. Thank you.
Good afternoon. My name is Robin Elliott, and I'm here today on behalf of the Maryland affiliate of the American College of Nurse Midwives in very strong support of this bill. The panel gave excellent testimony as to all the statistics. What I just wanted to add is that gun violence is a public health issue, and the bill before you takes a public health strategic approach to reducing the harm by safe storage policies. This will result in absolutely improved safety outcomes, improved health for our communities, and for that reason, we ask for a favorable report.
Okay, thank you. Excuse me. Okay, we'll have you testify next. Thank you.
Thank you, Madam Vice Chair, Madam Chair, and distinguished committee members. My name is Catherine Ling, and I am here today on behalf of the Maryland Association of School Health Nurses. We are charged every day to ensuring the health and well-being of the children who are in our care. Part of our job is to mitigate risk and to assess risk. Having firearms secured in a way that these children cannot use them in a moment is part of mitigating that risk. We know that youth suicidality takes time and patience for treatments to work. Making sure that lethal means such as firearms are not accessible gives the time and space to help these children grow and prosper. It also protects against accidental discharges, as they talked about. I know that this can end well sometimes. As a child, I had a firearm pulled on me that was unsecured. It ended well. But as a nurse for 36 years, I worked in emergency rooms, and it did not end well for a 5-year-old at their birthday party. It has not ended well in some of our schools. Responsible firearm ownership requires that you learn how to safely and constructively manage that piece of equipment and its lethality. We require that about cars and other lethal means that we allow people access to. We need to require that for firearms. So on behalf of the school nurses of Maryland, we ask for a favorable report for 1608. Thank you.
Thank you. All right, colleagues, questions on Delegate Archon.
Thank you so much, Madam Chair. Madam Chair, you can never have too many Madam Chairs, I think. So I was just reading through the bill, and on page 4, where it actually defines the stipulations around what a secure container is, I realized this might contradict our wear and carry laws. So you might remember we changed a lot of the wear and carry rules recently, and so as somebody with a wear and carry permit who wear and carries every day, I have to remove my firearm constantly now because of the new rules that we put in place, which means my car is my storage container. The way we wrote that law, it just has to be visually, you can't see it, and it has to be into the car. But the car doesn't meet any of these qualifications. So the way this is written, I worry that it would directly contradict the policy we just created around wear and carry. Did you guys talk about that at all when you were drafting it, or was that brought up at all?
It was not brought up. I just made a note.
Okay.
We can talk about it.
Okay,
we'll
yeah, because I see what the goal is and I see what you're trying to do. I just, now that I'm thinking about the way, what a car is, it just doesn't meet any of these, and it can't meet any of these. It's not,
Sure.
You can't stop fire from a car. You know what I mean?
Right.
I think the desire would be that if you're storing in your car, that we're taking it up a notch, that there are devices that you can purchase to store it in your car that would then satisfy the requirements. The kind of lock boxes that cable under your seat or get bolted down in your car in some way. There's all kinds of storage devices that are
We
made
did
specifically
discuss
for
that.
mobile.
Yeah, that was definitely discussed, and then it was ruled against the last time we did this.
So,
bill,
right,
which was a
that's
couple
not
years
in
ago.
the-
Yeah, that was definitely discussed when I mean, it was a couple years ago now, but we did discuss in detail if that would be feasible or reasonable. In the end, the body decided that it was not a reasonable expectation.
I think, sorry.
No, go ahead.
I think part of the problem at this point is that we're seeing so many more car thefts because people are storing them in their car. And then it's so
Correct.
easy to
Yes.
steal them out of cars that if
Yeah.
we take that to the next level and require that storage container, that, higher ranked storage container in the car, then you're helping to eliminate some of the gun thefts that are coming
This
from
was
cars.
directly when we drafted that bill, that was what we warned them. We said, now that everyone knows that we are no longer allowed to carry our firearms in so many locations, bad people will know they are now in cars. So, I mean, folks have stripped their NRA stickers off their car, so you wouldn't know that this person was, I mean, it's gotten a little bit silly, but I agree. I thought that wear and carry change was a terrible change, since now I'm an unarmed domestic violence victim walking around Maryland with some frequency, and my firearm is loaded into my car. That's not a great idea. However, I do not know how we can fix this in a way that allows for it to jive with the wear and carry. So we'll see if there's something that can be done on that. But my gut is telling me that would be a very hard line to draw.
Okay, thank you. Delegate Simmons.
Thank you, Madam Chair, and thank you, Madam Chair, for bringing this rapidly changing legislation. Of course, that incident y'all are referring to from last month was in my district at one of my elementary schools, and speaking with the staff and a lot of other people that was involved, the concern, out of safety, not only for that child, but for families, making sure that we educate them on safety around it. I want to speak to the school nurse in these environments that we're seeing when it comes to safety. Is there a screening process that parents, for example, fill out any questionnaires pertaining to a weapon in the household or anything like that, that we would be aware from a school's perspective of any concerns?
Not necessarily from a school's perspective. From a pediatric practice perspective, that is a regular safety question that gets asked. And as they get to be adolescents, what access do you have? Not is there one, but what access do you have? So it's not asked at this time.
Sure. In addition, with the schools, is there any training that takes place with schools, staff, or nursing staff around weapons or injuries resulting from weapons?
They're similar to what our colleague here who's undergone the shooter training, active shooter training. There are some stop the bleed components, but a full up disaster, there is not. I will tell you the 5 schools that I work with, we have been doing some professional development around what to do, and especially with an emphasis on psychological first aid, because just talking about it and what you see every day, you have concerns as well.
Thank you. Thank you.
Thank you, sir.
Delegate Conaway?
Thank you, Chair. Thank you, Chair, and thank you, panel, for coming in to testify. Well, it's very interesting. To the last person, I think, that gave testimony, who authorized, you said nurses might ask if there's a firearm in the house to a student?
It's part of a pediatric screening. When I'm also a nurse practitioner. And so when I do screenings with adolescents, I ask, do you wear a seatbelt? How long are you sleeping? There are certain routine assessments. And one of them is, do you have access to a firearm?
What do you mean when you do the screening? I mean, that a parent the parent takes their child to the doctor for the normal checkup? Is that what we're talking?
Exactly, yes, sir.
And during the normal checkup, the physical and all like this, you'll ask?
Absolutely.
About
Are your immunizations up to date? Do you wear a seatbelt? Are there firearms in the home?
Who authorized you to ask, do parents know that you're asking these questions?
They see all of the assessment. This is a routine assessment we ask. Do you have access to alcohol? Do you have access to drugs?
Okay, thank you so very much.
Certainly, thank you.
Delegate Woods. Chair, for this legislation, my question is for the high school student. I want to begin by just thanking you for your very well thought out, very well articulated testimony. It was greatly appreciated for this extremely important bill. And for the sake of a question, are you sure you don't want to be a page?
She's ours.
Thank you, Madam Chair.
Thank you, Delegate.
Delegate Mangio.
Thank you, Madam Chair. Thank you all for being here. So is this saying you need a safe, like a $5 gun lock? Would that suffice here, or is it has to be in a safe? I'm just trying to make sure I understand.
Yeah, it would most likely be more than just a simple gun lock. The statute or the bill defines secure storage depository to mean a safe or other secure container that when locked is capable of being opened without incapable of being opened without a key, keypad, or combination or any other unlocking mechanism, so.
And is it for an individual? What about a scenario like if I live by myself, for example, and have on a locked shotgun under the bed or with a lock, a gun lock, but it's not in a safe, but I have no kids? Does that make this, am I breaking the law
Yeah,
under
it
this
would be
bill?
a minimum standard for all gun owners.
So all gun owners?
Yeah.
And
Even though there's no kid, okay.
Well,
So
there's no children in your life today. Right?
Sure.
right, but also keep in mind that it's where you knew or, knew or should know that a child would gain access to it. So if you don't have any children in your home, then you don't have any children in your home, right?
I think that's for the
penalty.
For the penalty bump
Right.
is, the penalty bump is if there's a child that it has potential access. The standard, though, under
Section 41112?
Yeah, so it would set that standard, at a lower level, if you will, and then if there were youth in your life, then if you were charged, there would be that extra penalty bump because a youth got access.
Okay, I guess one of the real concerns too could be, especially a lot of I guess, single women, maybe some real abusive, we hear a lot about whatnot. If you're telling that, and anybody really, but that they have to take extra measures to lock, and they may not even have any kids in their lives, that could also have the opposite effect here on somebody that may have to, God willing they don't, but make a split-second decision to get access to a firearm for self-protection against somebody, and they do have it locked, but it's just not in the safe, which with all the nerves going on if somebody's breaking in your house. So I see both ways. I appreciate you being here, and I understand where you're coming from, and definitely have concerns, but thank you. It's interesting.
Yep, and I appreciate that, Delegate. I won't go on. I appreciate it.
All right, Delegate Valentine.
Thank you, Madam Chair. And thank you, Madam Chair and panel. I had a question, but to follow up on Delegate Mangione's question was about children. And I'm thinking, obviously, my wife and I, we don't have any children at home anymore, but we do have grandkids. And I'm trying to think, obviously, my firearms are obviously secured, and they would be secured if they're there. But on a day that maybe they wouldn't be, and I wasn't home, and I didn't know they were coming over with, for whatever reason, they may be somewhere where I wasn't planning on it, and my wife didn't know they were somewhere, how would this bill impact me in that scenario? And I don't want to go down what-if trails all day long, but just in that specific situation, under this bill.
He's basically asking if the storage is required, if there's the similar.
I think the idea here is that if you're always storing your firearm along these lines with a secured container, then you don't have to worry that if the kids come by accidentally, that the firearm is where it's supposed to be. If it's not on your person, if it's not in your personal control, then you're storing it in a secure box or depository or however we framed it. So then you're not constantly second guessing what scenario, do I need to move it today? Do I not need to move it today? If you're utilizing it, if it's in your possession or control, obviously it doesn't need to be in secure storage. Otherwise, you take those extra steps.
So the goal would be to mandate me to store this a certain way, no matter what my living arrangement would be?
Correct.
Okay. I did have a follow-up. Now, to my original question was on page 3, down about 3/4 of the page under number 3 for carried under direct control of the means of the authorized user, which I believe you just were talking about briefly. Number 2, close enough. I'm trying to define close enough to a firearm. I look at close enough as subjective. Are you trying to make that within a certain area? Is like, I know what within my area or within my reach. I'm trying to define close enough.
We can define close enough. Yep.
Thank you.
Thank you. I appreciate that.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Cardin.
Thank you, Madam Chair, and thank you for bringing the bill. And you know, anytime I can keep guns away from people, I love it. So I'm all about this. But I'm pulling up the definition. Okay. Shoot, I lost it. Oh, here we go. A safe or other secure container that, when locked, is incapable of being opened without a key, a keypad, a combination, or any other locking mechanism. So if I have it in my room, and my room is keypad protected or lock protected, my bedroom, and nobody can get in there without the keys, is that a container that is incapable of being opened without a keypad or a lock?
Yes.
So that's good.
Yeah, your entire room would be.
Would be the locker.
Mhm.
Okay.
Yeah.
So if I live by myself, my house would be my locker. So I would not be in violation of this if I reasonably expected nobody to be in my house because it's my house, I have it by myself, my house is locked with a key. I just want to make sure because I'm all about that.
Right, it's locked within the means of, so it's almost, if you're talking, to me, when you were going through that scenario, I was thinking of a panic room, okay? A panic room in a house.
Can't actually break into it.
And so something that, you couldn't break into, and it would fit within the definition here. So the entire room is almost like a storage facility. But given some of the testimony that I saw, that's something I think we can flush out a little bit more too.
Maybe tighten that up, but.
Yeah, we can flush that out.
Yeah.
And there are some suggested amendments. They weren't ready for today's hearing, so I didn't even touch on them. But I'm taking notes, and we'll also provide some more, some actual amendments.
I will ask Delegate Stein maybe to be in touch with you if he has any insights, because he did this bill or similar bills in the past that I think passed, and he may have some language.
Actually, Delegate Stein and I worked together on Jalen's law, and so this is an expansion of that bill.
Okay,
But yes,
great.
thank you so much.
Yep.
Thank you. Delegate Phillips.
Thank you, Madam Chair. And Madam Chair, I'm going to channel my inner Delegate Kaufman. Would you like to respond to 2A shall issue or Maryland shall issue and 2A and all those folks that talked about the constitutional challenges associated with this?
Yeah, and you know what, I respect the intelligence and the experience and the constitutional knowledge of both 2A and Maryland shall issue and their leaders. I think that it is notwithstanding some of the things that we have mentioned here today, I think that if those things were tightened up, then I feel very confident that we could overcome a constitutional challenge. However, keep in mind that we did not get an Attorney General opinion on this. And I may seek an Attorney General opinion, given this close towards the end of session. I may not be able to have time to do that. But I want to get the amendments in, see what it looks like, and see if we could possibly create a structure that is more in line with Bruin, Heller, and all the other well-known Supreme Court gun cases.
Okay. Delegate Arcan for a second bite of the apple.
Yeah, thank you, Madam Chair. So I was just thinking about what Delegate Cardin, his example was like the whole room essentially as a, so I'll tell you why I don't think that's possible, because a bedroom door or even a front door is not fire, impact, or tamper resistant. So it doesn't meet the third qualifying factor listed here. So, and it's also, you couldn't make a home not capable of an unauthorized person gaining access to the home. That's just not possible to do.
Well, I was doing it, I'm sorry to interrupt you, but I was thinking of it as, I mean, I saw the room with the show, what was the show, Panic Room or whatever? That's what I was envisioning when he was talking.
No,
and so I was thinking of something, not the entire home in the sense of like the smart homes we have now and all of that. I was envisioning, based on his example, when he first said room. And the room, and even if we had like, what were they called in World War II? The bunkers, something like that. I mean, the room, the entire room could be considered safe storage. Again, though, we're going to look at the safe storage depository language that we have here and make it clear as to whether or not it would be, I mean, I'm not going to put in dimensions. I don't think we need to put in dimensions. But the whole point is to meet this criteria or whatever it's amended to be, so that people have some type of framework to be able to understand that, okay, I am meeting the requirements that are listed here.
Yeah, so I know a lot of folks, what they'll do is if they have a small closet in their home, like a linen closet, for example, they'll take the handle off of it and replace it with thumbprint. So my question would be, for you to muse over, if it's a thumbprint lock on a wooden door that's a closet.
So now the fire part is not there.
Yeah, gotcha. Pretty much every door in a home, even, I mean, there's fire resistant doors that go between garages, but that can still be tampered with. It could still be, in the end, that door will fall because the frame around it is wood. The entire house is wood. I mean, we don't build concrete houses in America, which is a whole other mold discussion we should have in another committee, but anywho. So there's just a lot of things. If your goal is to make something like that lawful, then we got to think about the fire tamper resistant part.
That's helpful. Thank you.
All right, thank you. Any further questions for this panel? Seeing none, we have two virtual panelists, and this panel is excused, but we have two virtual panelists. We have Aaron Earp, thank you so much for being patient, and Layla Gretton, is she in?
She just testified. I just testified.
Excuse me?
I just testified.
Ah, it says you were virtual. Okay, thank you. So, Ms. Earp, you can proceed.
Good afternoon, Madam Chair and members of the committee. My name is Erin Earp, and I'm a senior policy attorney at the Giffords Law Center. I'm also a resident of Calvert County. Thank you for the opportunity to testify today in support of HB 1608, which will ensure that unsecured firearms do not result in child death, firearm suicide, or theft and diversion of firearms to illegal markets. Maryland law currently has no standard for the secure storage of unloaded firearms. This bill would prohibit storing or leaving a firearm in a location where the person knows or should know that a minor is likely to gain unsupervised access to the firearm, and would also require firearms to be stored in a secure, locked container when they're not being carried under the direct control of an authorized user. We know that the risk of suicide and unintentional shootings among youth increases in homes where guns are kept loaded and or unlocked. Estimates suggest that even modest increases in the number of homes safely storing firearms can prevent almost a third of gun deaths due to suicide and unintentional firearm injuries. A 2024 meta-review of 14 studies found that child access prevention laws were associated with a, quote, reduced pediatric firearm injuries and deaths, with the magnitude of the effect being proportional to CAB law stringency. In other words, the stronger laws had a bigger impact. Safe storage laws are also effective in preventing suicide in adults, preventing firearm thefts, which contribute to the illegal gun market where guns are then used in crime. And while I have not had a chance to review some of the written testimony related to the constitutional issues, I will say that this bill is very distinguishable from the DC law that was struck down in the Heller case. The Heller law required firearms to be, in all cases, kept unloaded and disassembled and not readily usable for self-defense, which was the issue in Heller. This law very clearly states that you can have your firearm on your person or under your direct control. It's only when you are when you do not have that gun on your person that it has to be securely stored. To my knowledge, there has not been a constitutional challenge that has been successful. There are over 20 states that have some version of a safe storage or child access prevention law. These are very common. And these laws establish a clear standard for the safe storage of firearms. And these laws save lives. And for all the reasons previously stated and the previous testimony of the panel, I urge a favorable report. Thank you.
Thank you. Colleagues, any questions for this witness? Okay, seeing none, that concludes the favorable panel for this bill. We're going to call the unfavorable panel, and there are two virtual witnesses, John Jocelyn and John Weber. Are they there? Mr. Weber's in person? Yes, ma'am. Thank you. You can have a seat, and we're going to call you and John Jocelyn. You can start, sir.
Chair and members of the committee, my name is John Weber, and I represent the National Rifle Association and our members in Maryland. The NRA is opposed to House Bill 1608. Maryland already has existing laws that require the storage of firearms to prevent minor access. HB 1608 removes key qualifiers like loaded and expands this to all firearms, imposing mandatory lock storage in fire-resistant containers. This shift invites severe consequences for minor oversights, punishes individuals who have no intent to harm. For instance, consider a law-abiding gun owner who stores a disabled, unloaded heirloom firearm in the attic for safekeeping. If a family member or visitor could theoretically access the attic without the owner's direct supervision, this could trigger a violation under the bill's broad knows or should know standard, leading to a misdemeanor charge on the first offense. Also consider people without children, the elderly, or people with active protection orders. This would apply to all of them too. Such examples highlight how this law criminalizes harmless everyday scenarios rather than targeting deliberate negligence. The bill's tiered penalties escalate quickly. A second violation carries a $1,000 fine, while a third effectively is a lifetime ban for a nonviolent offense. Criminals who already disregard laws will not comply with storage mandates, yet law-abiding citizens face these draconian outcomes. And they are put in this position of having to decide where and when to leave their firearm, when to keep it on their body, how to store it, vehicle issues, and other things that we've heard discussed today. Moreover, by carving out an explicit exemption for situations where an unauthorized person does access the firearm and uses the firearm lawfully in self-defense, HB 1608 implicitly acknowledges that its mandated secure storage requirement could otherwise restrict or delay defensive access in emergencies. This admission underscores the fundamental flaw. This bill prioritizes rigid compliance over the practical realities of home defense. We're opposed to this bill for those reasons and a number of others, but I'm happy to take any questions.
Thank you, sir. Mr. Jocelyn, you can proceed.
Good afternoon, Madam Chair. John Jocelyn speaking for 2A Maryland in opposition to House Bill 1608. The language of the bill makes it virtually impossible to keep a firearm in a person's home for self-defense unless the firearm is on the person or within the person's arm reach. Now, here's why. The bill requires that all firearms, handguns and long guns, be stored in a secure storage depository, which is defined as something which is, when locked, incapable of being opened, is capable of preventing an unauthorized user, is fire, impact, and tamper resistant. These 5 subjective terms are undefined, and thus the term secure storage facility is equally undefined. This language is, in my humble opinion, unconstitutionally vague. Yet Section 41045 permits the access by a minor for lawful self-defense, and 4112B contains a similar provision. How the minor unauthorized user is able to gain access to the firearm in a secure storage depository is a bit of a mystery. However, it could explain the fact that the bill's language does not require that the container be locked. Should be noted that this bill will impact minorities and low-income communities disproportionately. The fiscal note does not reflect that. The cost of the normal storage mechanism that would appear to comply with the 5 points, we're looking at anywhere from $600 to $4,000. The language itself is confusing, and it reminds me very much of Ayn Rand's Atlas Shrugged, where she wrote, "What's wants a nation of law-abiding citizens? What's in that for anyone? But just pass laws that can neither be observed nor enforced or objectively interpreted, and you create a nation of lawbreakers, and then you cash in on the guilt." Ayn Rand was a lady far ahead of her time. We ask for an unfavorable report on House Bill 1608.
Thank you, sir. All right, colleagues, Delegate Carton.
Thank you, Madam Chair. Thank you very much for your testimony, sir. Appreciate it. So I'm going to ask, so my grandfather, who was a circuit court judge and lived by himself for 20 years after his wife died, my grandmother, and when he died, I went in, and I used to go to his house as a little kid and play around, go into closets, do all kinds of stuff. I went in to clean his house after he passed away. I was a young legislator. And I found an old Smith & Wesson revolver. And I pulled it out. It was all rusted. It was certainly not operable. However, if 20 years earlier, as a little kid, I had been going around and just kind of and found the gun, even if it wasn't operable then, and it probably was, and I started, I put it in my pocket, I maybe took it, I sometimes took things from him and would bring him back the next week. Tell me how, even if, because you gave your attic scenario, like an inoperable gun in the attic. Is it okay to have little kids playing with inoperable guns, even if they can't shoot themselves or other people? So I guess that's my, because this could have happened to me. I mean, that could have been me.
So your father had that gun unsecured in the house when you were a child?
Yeah, I mean, I found it in his closet, sitting there on top of his.
And he was living alone at the time?
What's that?
And he was living alone at the time?
He was living alone at the time.
Okay.
This is 30 years ago, 25 years.
He had an inoperable gun, he was living alone at the time. Yeah, I mean, like I said, I think the mandate is the problem. I don't know if you had that stored when you were living at the house. People get older, their muscle memory, their dexterity fails. As I also mentioned, people that have active restraining orders, protective orders, all of these people would be forced to put these things in a place where they can access them quickly. The bill acknowledges that that's a problem by giving after the fact legal cover for unauthorized people who do access a firearm in that exact scenario to defend themselves.
Okay. Thank you. Thanks. Appreciate it.
All right. Delegate Simmons.
Thank you, Madam Chair, and thank you for coming out. And so when we look at responsible gun ownership, we often talk about that here and what that means when it comes to the advocates and those gun owners. When you look at in a residential home, individuals that may own a weapon, and what is the number of individuals are you aware of that may have had a weapon stolen from their house?
The gross number of individuals?
Yeah, here in Maryland. I don't know if you have any Maryland numbers. I was just trying to get a...
I don't know that off the top of my head. I'd be happy to try to find out. And let
Sure,
you
sure.
know.
So when it comes to your membership, how many members here in Maryland do y'all have?
We don't disclose our individuals.
Y'all don't disclose your, okay, sure. So would you say, speaking from the industry standpoint, do you think it's responsible for every responsible gun owner to make sure that they maximize securing of their weapon in all circumstances?
Well, I don't speak for the industry. I speak for individuals.
Okay.
We offer a lot of courses for individuals on proper firearm handling and all sorts of things. The mandate's the issue.
Right.
We believe people should be able to lock these things up. I think if they have different situations, again, like protective orders or being old, there's different things. So, some people live in different situations. Maybe some people should lock up medications. Maybe
Sure.
some people shouldn't. Maybe some people should lock up knives. Maybe some people shouldn't.
Sure.
It's a household by
Yeah,
household.
the interesting thing when they referenced the earlier testimony, the Freetown Elementary shooting, where the young kid, second grader, accessed his mother's boyfriend gun, who was a military reservist, a recruiter. The story behind that is that they believe that he had brought a weapon to school prior to that incident. So when we're talking about holding people, now he's a responsible gun owner. So when we talk about holding people accountable, what do you think some of his options could have been?
But he's a responsible gun owner. Isn't there currently a law that gun should have been locked?
Sure.
And he's a responsible gun owner. And how'd the kid get the gun?
He just took it.
But it was locked?
No, it wasn't.
But he's a responsible gun owner?
You tell me.
Well, he wasn't following the law.
Okay.
That would be an issue. Okay.
Thank you.
All right, thank you. We're going to go to Delegate Arcan and then Delegate Mangio.
Thank you, Madam Chair. I just wanted to ask, I know, Mr. Jocelyn, you worked with us a lot when we were writing the wear and carry policies. So I remember that we decided against requiring some type of safe box in every car. Do you remember if the available on the market safe boxes would qualify under the fire-resistant, tamper-resistant language? I feel that we maybe discussed this exactly, but it's been a few years, but I feel like that doesn't actually exist. I feel like there's actually nothing that would actually qualify under those qualifiers. Do you recall?
I do have some recollection where we did discuss that. Of course, this bill was not in play at the time. I will tell you that based upon the criteria that the bill contains, which states when locked is incapable of being opened. Incapable of being opened by whom or by what? That's an open-ended mandate right there. Incapable. That's an absolute. Nothing will meet that criteria.
Right.
Is capable of preventing an authorized person from obtaining access. Again, that's an absolute. Are we talking about a 6-year-old or are we talking about a 20-year-old who has a metal grinder and can cut through? Fire resistant, to what level? Fire resistance in building codes is the complete burn, surviving structurally, the complete burnout of the building and its contents. That doesn't directly apply, but it gives you an idea that there are definitions out there. For most storage containers, it's listed as being at a given temperature for a given period of time. This bill strictly says is fire resistant. What does that really mean? Impact by what? Tamper resistant, how does one define tamper? There are so many open-ended questions that these vague definitions and lack of bring forward. You couldn't establish what really is a proper container to put in your car or your house. None of these can you really interpret properly.
Yeah, and remember we've had, like, I think even in Anne Arundel County and I think maybe Baltimore County as well, we had libraries very recently still giving away those like lock things that you can run through the barrel. Those are being given away by the state and they're a violation.
They would not comply with this particular bill, and you are correct. Anne Arundel County gives them away at the libraries. Their gun violence reduction, I can't remember exactly what they call the program. Baltimore County libraries do the same thing, as do the Baltimore County Police Departments. For my students, my source of cable locks for students is from the Baltimore County Library. They give them to me for free. I give them to my students for free.
And they're not even a lawful form of storage. So it's like the left hand doesn't know what the right hand is doing.
Under this criteria, no, they would not apply, and we've given them a false sense of security that they're in compliance with the law.
Right. Okay. Thank you so much for being here.
Delegate Mangio.
Thank you, Madam Chair, and thank you both. And I just want to touch back on, because the good delegate whose grandfather was a judge makes a good point, but at the same time, let's take that scenario. Here he is as a judge, living on his own, probably under more of a threat of retaliation than anybody in public office, probably more so even than a politician because of what a decision a judge may make. And he's an older gentleman. I want to see what you say or have to say and touch on what kind of delay it could mean to have to store your device in one of these storage units that they're requiring. If, say, you are an older individual who's under a threat constantly, and now here's a real, I mean, let's be honest, we just were in here a couple of weeks ago to push a bill, and we all voted for it, I believe, which is a good thing, on a judge who was assassinated. So the point is, I'm using that as an example of somebody that you mentioned in your testimony could really be under a serious threat, and now they have to make a life-changing decision to access a firearm for self-protection. How much of a delay could you see if it's required in this bill to be in one of these particular safes? Again, who lives by themselves, very rare, has children there.
Yeah, I mean, in terms of time, it's hard to say. But in terms of physiology, when you're under that sort of stress response, your body pulls blood into your center cord, into your brain, and away from your limbs, your fingers, your appendages, slowing down your response time. The stress can actually inhibit your thought to the level in a way that also slows things down. So it can be, you know, when seconds count, it can take minutes.
I don't know if the gentleman wanted to respond also.
Delegate, were you speaking to me, sir?
Yes, unless you, and if you have nothing to add, I'll just say.
Actually, under stress, several things happen, one of which is tunnel vision. The other one, physiologically, is your loss of fine motor skills, your ability to manipulate smaller objects. That would be keys or a combination lock. Keypads might be a little better. A biometric is problematic. I have a biometric on my laptop, and sometimes it recognizes my fingerprint, and sometimes it doesn't. So yes, there is definitely going to be a delay.
Well, thank you both. I mean, it is a concern. We want to protect children and accidents from happening, but of course we want to protect the rights of people, especially when it comes to the Second Amendment. So thank you for your expertise.
Thank you.
Thank you. Any further questions for the unfavorable panel? Seeing none, this concludes the hearing on HB 1608. Thank you all for being here. And this concludes the hearings for today of the House Judiciary Committee. Thank you. Members, we will be having the vote session in about 15 minutes. So around 3. Of our subcommittee hearings, subcommittee meetings, but it won't be well, it depends on how long the voting session goes. Right?